Welcome, I'm Sharon Abaud, immigration attorney. In this video, I'm going to do a follow-up of a video I did a few weeks back. So a few weeks ago in June 2019, I gave you some news about the F2A being current in July, and now it's July and it looks like it's still current. I want to do a follow-up, answer some questions I've been getting for those of you adjusting status. This is important information, so please stay tuned. Before I get started on today's video, I want to remind you to go ahead and subscribe to my channel and click the bell to get notifications every time I upload a new video, and that way you learn the latest and you're on top of your case. So now that we're in July, as I already mentioned, the visa is current for F2A, that is for spouses and minor and children, unmarried children of lawful permanent residents. So that is great news for many. What I didn't go into so much was who could qualify for this adjustment of status and if you could file at the same time as the I-130, since all these visas, according to the visa bulletin, are immediately available. And there was a lot of back and forth whiplash going on whether you could or you couldn't, and we were sort of waiting on USCIS to give us word on that, and it looks like you can in fact file at the same time the I-130 and I-485 now that the visa bulletin is current. USCIS is allowing that, so that's great news. Now, something to be mindful of when you are filing as the spouse of a lawful permanent resident, you are not considered an immediate relative because you're not the spouse of a U.S. citizen. It's not the same thing. That's why you're put on this waiting list. That's why you're given a preference category, because you are not an immediate relative. So what that means is that you're not exempt from a bar to adjustment of status. So if at the time that you file adjustment of status, you are out of status, even if you entered legally, but now your status expired. If at the time that you are filing for adjustment of status, that status expired, you cannot file for adjustment of status. You will either have to wait for your spouse to become a citizen or see if you qualify to immigrate abroad at a U.S. embassy. So that is really important information. Now, there is an exception for those of you with 245I. 245I does exempt this. So if you were here without status at the time of filing for adjustment of status and you have 245I, which means a petition was filed for you before April 30th, 2001, then you may be exempt from this bar. With that said, I remind you guys the importance of doing a consultation with an attorney to make sure that you get advice for your individual case, because every case can be different and some advice may apply to you or may not, and it's always best to get the one-on-one consultation to make sure you're following the right steps. Well, I'm Sharon Abaud, immigration attorney. Again, if you enjoy these videos, make sure you subscribe and you click the bell to get updates on the next video. Thank you. Until next time.